My Lords, I have thought it important to set out with some fullness the conflicting views in the Court of Appeal. It is obvious that two of the judges there based their conclusions on the principle that in the absence of a direction to the contrary, which they could not find in the statute, the analogy of the procedure in a court of justice must guide them. Lord Justice Hamilton, on the contrary, thought that he found in the statute a scheme of procedure that excluded this analogy. Which of these opinions was right can only be determined by referring to the language of the legislature. Here, as in other cases, we have simply to construe that language and to abstain from guessing at what Parliament had in its mind, except in so far as the language enables us to do so. There is no doubt that the question is one affecting property and the liberty of man to do what he chooses with what is his own. Such rights are not to be affected unless Parliament has said so, but Parliament, in what it considers higher interests than those of the individual, has so often interfered with such rights on other occasions that it is dangerous for judges to lay much stress on what 100 years ago would have been, page 131, a presumption considerably stronger than it is today. Page 132. My Lords, when the duty of deciding an appeal is imposed, those whose duty it is to decide it must act judicially. They must deal with the question referred to them without bias, and they must give to each of the parties the opportunity of adequately presenting the case made. The decision must be come to in the spirit and with the sense of responsibility of a tribunal whose duty it is to mete out justice. But it does not follow that the procedure of every such tribunal must be the same. In the case of a court of law, tradition in this country has prescribed certain principles to which in the main the procedure must conform. But what that procedure is to be in detail must depend on the nature of the tribunal. In modern times it has become increasingly common for Parliament to give an appeal in matters which really pertain to administration, rather than to the exercise of judicial functions of an ordinary court, to authorities whose functions are administrative, and not in the ordinary sense judicial. Such a body as the Local Government Board has the duty of enforcing obligations on the individual which are imposed in the interests of the community. Its character is that of an organisation with executive functions, in that it resembles other great departments of the state. When, therefore, Parliament entrusts it with judicial duties, Parliament must be taken, in the absence of any declaration to the contrary, to have intended it to follow the procedure which is its own, and it is necessary if it is to be capable of doing its work efficiently. Page 1 through 3. In the case of the Local Government Board, it is not doubtful what this procedure is. The minister at the head of the board is directly responsible to Parliament, like other ministers. He is responsible not only for what he himself does, but for all that is done in his department. The volume of work entrusted to him is very great, and he cannot do the bulk of it himself. He is expected to obtain his materials vicariously through his officials, and he has discharged his duty if he sees that they obtain these materials for him properly. Unlike a judge in a court, he is not only at liberty, but is compelled to rely on the assistance of his staff. When, therefore, the board is directed to dispose of an appeal, that does not mean that any particular official of the board is to dispose of it. It is said that the report, page 134, of the inspector should have been disclosed. It might or might not have been useful to disclose this report, but I do not think that the board was bound to do so, any more than it would have been bound to disclose all the minutes made on the papers in the office before a decision was come to. I do not think the board was bound to hear the respondent orally, provided it gave him the opportunities he actually had. Moreover, I doubt whether it is correct to speak of the case as a lis inter partes. The Hampstead Borough Council was itself acting administratively, although it had the right to appear, and did appear, before the inspector, and on the appeal it might have to pay or receive costs. End quote. Page 136, Lord Shaw of Dunfermline, quote, "It is said that the respondent is entitled to know his particular judge or judges, to individualise the board, and to demand that that person or those persons so discovered shall give him, the respondent, an audience on the whole material available, including the result of the public local inquiry and the report made thereupon by the board's inspector. In the first place, of the demand to know the individual judge or judges, my lords, how can the judiciary be blind to the well-known facts applicable not only to the Constitution, but to the working of such branches of the executive? The department is represented in Parliament by its responsible head. His board, that is, all the members of it together, may never meet, or they may only be convened on some question of policy, but a determination, signed and sealed and issued in correct form, stands as the deliverance of the board as such, for which determination the President becomes answerable to Parliament. The next proposition is this, that when a public local inquiry has been held in compliance with statute, the person whose interests are affected is entitled to something more, namely, a disclosure of the views of the inspector written out by him, in jottings or otherwise, for the guidance or consideration of the department in dealing with the case. Page 137. I incline to hold that the disadvantage in very many cases would exceed the advantage of such disclosure, and I feel certain that if it were laid down in courts of law that such disclosure could be compelled, a serious impediment might be placed upon that frankness which ought to obtain among a staff accustomed to elaborately detailed and often most delicate and difficult tasks. Page 138. The words natural justice occur in arguments and sometimes in judicial pronouncements in such cases. My lords, when a central administrative board deals with an appeal from a local authority, it must do its best to act justly and to reach just ends by just means. If a statute prescribes the means, it must employ them. If it is left without express guidance, it must still act honestly and by honest means. In regard to these, certain ways and methods of judicial procedure may very likely be imitated, and lawyer-like methods may find especial favour from lawyers. But that the judiciary should presume to impose its own methods on administrative or executive officers is a usurpation, and the assumption that the methods of natural justice are ex necessitate those of courts of justice is wholly unfounded. End quote. Page 146, Lord Moulton, quote, I have no doubt that the new procedure as to appeal was intended to be an appeal to a superior executive body as such, and that it was not intended that the local government board should act in a purely judicial capacity. There is no doubt that it must act in a judicial temper. Its order might confirm an order of the local authority interfering with the property, page 147, of a private individual, and thereupon that order would be capable of legal enforcement. In the exercise of such powers, the local government board would be bound to treat the matter in a judicial spirit, availing itself of the wide powers solely for the purpose of carrying into effect in the best way the provisions of the Act. But although in this sense it must act judicially, there was not, in my opinion, any obligation upon it to follow wholly or in any special respects the procedure of a court of justice, provided that the procedure adopted by them was consistent with their performance of their duties judicially in the sense to which I have referred. Page 151. There is one point which needs notice, namely, the claim that the respondent was entitled as of right to see the report of the inspector who held the public inquiry. No such right is given by statute or by an established custom of the department. Like every administrative body, the local government board must derive its knowledge from its agents, and I am unable to see any reason why the reports which they make to the department should be made public. It would, in my opinion, cripple the usefulness of these inquiries. It is not for me to express my opinion as to the desirability of an administrative department taking any particular course in such matters, but I entirely dissociate myself from the remarks which have been made in this case in favour of a department making reports of this kind public. Such a practice would, in my opinion, be decidedly mischievous. End quote. Rex and Halliday, L.R., 1917, Appeal Cases 260. Held by the Lord Chancellor, Lord Finlay, and Lords Dunedin, Atkinson and Wrenbury, Lord Shaw of Dunfermline dissenting, that an order for the internment of a naturalised British subject of German birth made during the Great War in pursuance of a regulation for securing the public safety and the defence of the realm under the Defence of the Realm Consolidation Act 1914 was valid. Page 264, the Lord Chancellor, Lord Finlay, quote, My Lords, the appellant in this case is a naturalised British subject of German birth who has been interned by an order made by the Secretary of State under the powers of Regulation 14b, which was made under the Defence of the Realm Consolidation Act 1914. It was contended on behalf of the appellant that Reg 14b was not authorised by the Act and was ultra vires. It is beyond all dispute that Parliament has power to authorise the making of such a regulation. The only question is whether on a true construction of the Act it has done so, after setting out the provisions of Section 1, subsection 1 of the Act and of Reg 14b of the Defence of the Realm, page 266, brackets Consolidated Regulations, his Lordship proceeded. It will be observed that any action of the Secretary of State under this regulation is to be upon the recommendation of a competent naval or military authority or of an advisory committee. If on such recommendation it appears to the Secretary of State that, for securing the public safety or defence of the realm it is expedient so to do, he may subject any person of hostile origin or associations to, page 267, certain restrictions, one of which is internment. The order must, however, include provision in the case of any person not being an enemy subject for consideration of any representation which the person affected may make against the order by an advisory committee, which is to be presided over by a person who holds or has held high judicial office. The regulation, therefore, provides means for ascertaining whether any complaint against the justice or necessity of the order is well founded. Page 268. It was contended, 1. That some limitation must be put upon the general words of the statute, 2. That there is no provision for imprisonment without trial, 3. That the provisions made by the Defence of the Realm Act 1915 for the trial of British subjects by a civil court with a jury strengthened the contention of the appellant, 4. That general words in a statute could not take away the vested rights of the subject or alter the fundamental law of the Constitution, 5. That the statute is in its nature penal and must be strictly construed, 6. That a construction said to be repugnant to the constitutional traditions of this country could not be adopted. Reference was made by the appellant's counsel to the history of the various interferences with the right to habeas corpus in times of public danger, and it was urged that if it had been intended to interfere with personal liberty, this is the course which would have been adopted. I am unable to accede to any of the arguments urged on behalf of the appellant. It was not, as I understand the argument, contended that the words of the statute are not in their natural meaning wide enough to authorise such a regulation as Reg 14b, but it was strongly contended that some limitation must be put upon these words, as an unrestricted interpretation might involve extreme consequences, such as, it was suggested, the infliction of the punishment of death without trial. It appears to me to be a sufficient answer to this argument that it may be necessary in a time of great public, page 269, danger, to entrust great powers to His Majesty in council, and that Parliament may do so, feeling certain that such powers will be reasonably exercised. Page 270. The statute was passed at a time of supreme national danger, which still exists. The danger of espionage and of damage by secret agents to ships, railways, munition works, bridges, etc. had to be guarded against. The restraint imposed may be a necessary measure of precaution, and in the interests of the whole nation it may be regarded as expedient that such an order should be made in suitable cases. This appears to me to be the meaning of the statute. Every reasonable precaution to obviate hardship which is consistent with the object of the regulation appears to have been taken. It was argued that if the legislature had intended to interfere with personal liberty, it would have provided, as on previous occasions of national danger, for suspension of the rights of the subject as to a writ of habeas corpus. The answer is simple. The legislature has selected another way of achieving the same purposes, probably milder as well as more effectual than those adopted on the occasion of previous wars. The suggested rule as to construing penal statutes and the provision as to trial of British subjects by jury made by the Defence of the Realm Act 1915 have no relevance in dealing with an executive measure by way of preventing a public danger. End quote. Lord Dunedin. Quote, it is pointed out that the powers, if interpreted as the unanimous judgment of the courts below interprets them, are drastic and might be abused. That is true, but the fault, if fault there be, lies in the fact that the British Constitution has entrusted to the two Houses of Parliament, subject to the assent of the King, an absolute power untrammelled by any written instrument, page 271, obedience to which may be compelled by some judicial body. The danger of abuse is theoretically present. Practically, as things exist, it is, in my opinion, absent. End quote. Page 276, Lord Shaw of Dunfermline. Quote, I am of opinion that the judgments appealed from are erroneous in law, and that they constitute a suspension and a breach of those fundamental constitutional rights which are protective of British liberty. The appellant is a naturalised citizen of this country, that is to say, on the one hand he owes submission to, and on the other he is entitled to the protection of, our laws. That is the essential pact underlying naturalisation. The war made no difference to this. Page 277. I am clearly of opinion that, although bearing to be a regulation, this is, in truth and essentially, not a regulation at all, and that it was ultra vires of His Majesty in Council to issue, under the guise of a regulation, an authorisation for the apprehension, seizure, and interment without trial of any of the lieges. In my view, Parliament never sanctioned, either in intention or by reason of the statutory words employed in the Defence of the Realm Acts, such a violent exercise of arbitrary power. It follows that the order or fiat of the Secretary of State, which has already been quoted, is also ultra vires. Page 278. My Lords, the Act of Parliament, as we shall see, does employ the words, for securing the public safety and the defence of the realm, but there is not one word in the Act of Parliament about hostile origin or associations of any person, nor indeed about internment. These are not statutory terms. Parliament might very well have taken the subject of hostile origin or associations into its account, and Parliament might very well have considered the subject of internment and dealt with it. Had it done so, courts of law would have been bound to comply with any verdict on the subject which it embodied in statute. Accordingly, the first great and broad fact confronting your lordships in this case is that in a matter so fundamentally affecting the rights of His Majesty's subjects, Parliament has given no express sanction for the introduction of that language, hostile origin or associations, and what remains is the argument that Parliament, not expressly dealing with a matter preeminently demanding careful delimitation, must be held to have accomplished by implication this far-reaching subversion of our liberties.